Good afternoon, Mr. Chairman and Committee. I'm Dan Foreman, Idaho State Senator, District 6. I'll be presenting Senate Bill 1233, otherwise known as the Constitutional Courts Act. This bill creates a new section, 1-1626 of Idaho Code. Constitutional Courts Act states that no state court at any level of jurisdiction or authority shall enforce, consider, or apply any judgment, decree, ruling, or decision of arbitration based on a body of religious or cultural law that does not fully support and conform to the rights of citizens as defined in the United States Constitution and the Constitution of the State of Idaho. The Constitutional Courts Act does not seek to ban any body of religious law or body of rules as applied to the day-to-day application of such in the private lives of citizens. Article 6 of the U.S. Constitution, known as the Supremacy Clause, holds that the Constitution and the laws of the United States are the supreme law of the land, and the judges in every state shall be bound thereby. The First Amendment to the Constitution states, Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. Article 1, Section 1 of Idaho's Constitution states all men are by nature free and equal. Article 1, Section 4 of the state constitution says the exercise and enjoyment of religious faith and worship shall forever be guaranteed, and no person shall be denied any civil or political right, privilege, or capacity on account of his religious opinions. Now, some examples of religious and cultural law are as follows. We have Hinduism. The concept of dharma embodies ethical obligations, caste-related rituals, marriage practices, and general individual behavior in society. We have Jewish law, called halakha, covers many things influencing Jewish society, including dietary laws known as kashrut, marriage, divorce, and family matters. Saudi Arabia, Sharia courts mandate that issues like marriage, divorce, and inheritance are handled in accordance with Islamic law. Sharia law governs family matters, finance, and food preparation, and its halal food preparation rules prohibit certain types of food. Sharia law also controls the criminal justice system, mandating capital punishment for certain offenses. And with your permission, Mr. Chair, I would like to read from an article published by the National Center for Constitutional Studies, dated January 11th, 2018. The author is a Mr. Earl Taylor, Jr.
Go ahead, Senator.
Thank you, Mr. Chair. Well, once again, this legislation does not single out any particular body of religious or cultural law, and I offer the information from this publication as only one example of one body of religious and cultural law that is incompatible with American values and our way of life. This information should serve as justification of the need for this proposed legislation. Now, throughout the history of this world, there really have only been two kinds of law. They are ruler's law and people's law. Under ruler's law, the king or dictator makes the law. Under people's law, the people make or accept the laws by which they live. In following the example of ancient Israel, America's founders set forth laws based on the laws of nature and nature's God. It has catapulted the United States to an unmatched position as the most prosperous and freest nation on earth. Now we are faced with the same kind of threat that has been seen in the past, a system of compulsory laws which has the use of force at its very core, in which claims to emanate from God. It is called Sharia law. The Arabic word Sharia is a term used to describe the rules of the lifestyle ordained by Allah. In practical terms, Sharia includes all the do's and don'ts of Islam. Sharia is held by mainstream Islamic authorities to be the supreme law that must comprehensively govern all aspects of Muslims' lives, irrespective of when or where they live. Sharia is characterized as a complete way of life, social, cultural, military, religious, and political, governed from cradle to grave by Islamic law. Whether pursued through the violent form of jihad, which is holy war, or stealthier practices, Sharia rejects fundamental premises of American society and values, such as the bedrock proposition that the governed have a right to make law for themselves, the democratic republic governed by the Constitution, freedom of conscience and individual liberty, freedom of expression, including the liberty to analyze and criticize Sharia, economic liberty, including private property, equal treatment under the law, including that of men and women, and Muslims and non-Muslims, freedom from cruel and unusual punishment, and a condemnation of terrorism that does not rationalize barbarity as legitimate resistance, an abiding commitment to resolve political controversies by the ordinary means of our democratic republic, not wanton violence. John Quincy Adams, our sixth president, wrote a 136-page series of essays on Islam that displayed a clear understanding of the threat facing America then and now from the permanent Islamic institution of jihad. Adams wrote, Muhammad declared undistinguishing and exterminating war as a part of his religion against all the rest of mankind. The precept of the Koran is perpetual war against all who deny that Muhammad is the prophet of God. It is clear from the writings of several of our earliest presidents, as well as the text of the nation's founding documents, that American principles are not at odds and imperiled by some radical or extreme version of Islam. Rather, it is the mainstream doctrine of Sharia that constitutes the threat to the U.S. Constitution and the freedoms it enshrines. The Sharia legal code cannot be insinuated into America without violating the Constitution's Article 6 Supremacy Clause, which requires that the Constitution shall be the supreme law of the land. Mr. Chairman, I'm done quoting from that article, and with your kind permission, I would like to quote from another article entitled Policy Brief, The Threat of Radical Islam and Sharia Law by the staff of the Center for Renewing America. It's dated December 9th, 2025.
Go ahead, Senator.
Thank you, Mr. Chairman. For its Islamic practitioners, Sharia supersedes the United States Constitution and explicitly rejects both biblical moral authority and the long-standing Christian understanding of natural rights, two foundational elements of Western civilization. Reports of secret Sharia courts operating in North Texas have been around for at least a decade, suggesting that groundwork for the Islamification of the area has long been underway. Governor Greg Abbott recently directed law enforcement entities in Collin and Dallas counties to investigate a reported Sharia court operating in Dallas. In non-Muslim nations, Sharia is typically first tested as a shadow form of law before enough political power is accumulated to make it the de facto framework for the Muslim community. Islamist strategy is ultimately to subvert the American constitutional order and replace one civilization with another. Sharia law is designed to eradicate the First Amendment, which forbids a state-established religion while guaranteeing the right of people to practice their faith unhindered in the public square. The growing support for Sharia law is a concerning sign of Islam's influence in the West. Polling from a decade ago shows that a substantial number of American Muslims surveyed believe that Muslims should have the choice of being governed according to Sharia law as opposed to the United States Constitution. A poll released by the Center for Security Policy showed more than half of U.S. Muslims polled believe that they should have the choice of American or Sharia courts, or that they should have their own tribunals to apply Sharia. It is essential to note that some of the specific provisions of Sharia law that would be applied to everyone under Islamic law include the following: honor killings and stoning to death as punishment for adultery, death as punishment for leaving Islam and converting to another religion, polygamy as an acceptable practice, corporal punishments including stoning, lashing, and amputation of limbs for certain crimes such as theft, blasphemy, and adultery. In a constitutional republic founded on principles such as religious liberty and the rule of law, built on a Judeo-Christian framework, there is simply no place for Sharia law, which explicitly aims to replace all forms of government, politics, economics, law, and human social interactions with strict precepts derived straight from the Quran and Hadiths. Sharia law is not only incompatible with Western forms of government, but explicitly at war with them. Sharia law should be considered unconstitutional because it conflicts with principles seminal to that document. It violates the Establishment and Supremacy Clauses and violates individual rights such as gender equality that are strongly supported by our Constitution. It can also be argued that Sharia law does violate the rights of minority groups such as women and members of different religious faiths and is therefore not compatible with American values pertaining to equality and justice. Now, the states of Alabama, Arizona, Kansas, Louisiana, North Carolina, South Dakota, and Tennessee have all passed legislation banning Sharia law from being used in their state courts. The Constitutional Courts Act does not seek to discriminate against Muslims or any other body of citizens based on religious or faith-based grounds. It proposes no restrictions on the private practice of any religion and is therefore in support of the First Amendment of the U.S. Constitution. The Act also directly supports the Supremacy Clause of the Constitution by supporting the mandate that the U.S. Constitution and U.S. federal law constitute the supreme law of the land. This legislation has been coordinated with the Idaho State Supreme Court and the Idaho Attorney General's Office, and both entities advise they have no concern with the legislation as written. Mr. Chairman, I'd be happy to take any questions.
Thank you, Senator Foreman. Appreciate your testimony and your work on this. Questions for Senator Foreman? Senator Ruckte.
Thank you, Mr. Chairman. Senator Foreman, I recognize the thrust of your remarks were on Sharia law, but my understanding based on the language of the bill and our discussion at the print hearing that your intent, and it's all asked as a question, is it your intent with the language of this bill to ensure Idaho courts and their decisions adhere to the concept of separation of church and state?
Senator Foreman.
Thank you, Mr. Chairman. Senator, no. There is no such concept as separation in church and state as listed in the U.S. Constitution. There really is no separation. When you look back at the history of our nation, our original set of laws were based on Judeo-Christian principles, so there was an interface with religion there. However, our Constitution says there will be no state religion. So if people want to interpret that as separation of church and state to a limited extent, I guess they can run with that. The only reference I've ever seen documented officially with respect to separation of church and state was in a letter that Mr. Thomas Jefferson wrote to a small religious sect, a sect that was concerned because of what they had experienced living in England, that because they were a small religious group, that the new government in the colonies would impose some sort of state religion on them. And Mr. Jefferson said, and I'm paraphrasing, in keeping with our effort to separate government control from religion, there will be no state religion, and therefore they were in no danger of losing their religious identity. But so the purpose of the bill is quite simple. To answer your question a little more directly, and I think we need to stay focused on it. It simply says no body of religious or cultural law will be used in our courts if it does not conform and support the rights of the citizens as listed in the Constitution. And I know how easy it is to slide into ancillary discussions, peripheral discussions about what this bill means. That's all it means. It's simply a reassertion for our respect for and appreciation of our court system as it exists. those that say, well, religion should have no influence in the courts. Well, if you pick up a history book, I'm here to tell you, religion has and does still have an influence. The system is what it is. I'm not here to debate whether that system is the best in the world, the worst in the world, or whatever. I'm here to say that the system is ours. We've had it for 250 years, pretty close, and we're not amenable to having any type of body of religious law or cultural law come and replace it if it doesn't represent the constitutional rights, fully support the constitutional rights of the people.
A follow-up, Senator?
Yes, thank you. Thank you, Mr. Chairman and Senator Foreman. Let me approach it this way. And I'll be clear, I don't agree with your position on separation of church and state, but be that as it may.
Okay.
Is it your intent with the language of this bill to ensure Idaho courts and their decisions do not promote religion or promote one religion over another?
Senator Foreman.
Thank you, Mr. Chairman and Senator Ruckty. I would support the prohibition on supporting one religion over another because that would violate the First Amendment of the Constitution. That already exists. Again, I go back to my intent is to protect and defend the system we have with all its foibles and flaws and with all its good points. I don't want to see it replaced by something that basically does not honor our rights under the Constitution. So the judges are free to act as they see fit, as they have been doing. However, they must do so with reverence for constitutional law.
Thank you, Senator. Okay, I don't see any other questions. Senator Foreman, we'll let you have a seat, and then we'll have some public testimony, and we'll let you conclude.
Thank you, Mr. Chair.
You're welcome. So, folks, I have a number of people signed in largely in favor of 1233 on this sign-in sheet. One opposed but does not wish to testify. And I would say most that I have signed in don't wish to testify, but I'll ask that question as we go along. I always want to start public testimony as first an expression of appreciation for you taking time to be with us. This is the People's House, and we're here to listen to what you have to say. And part of it being the People's House is that we have different opinions on legislation that's brought. And so I always ask both sides on any issue to be courteous and respectful of the other. Give them their opportunity to express their view to us as a committee, and I ask the same of them. So please be courteous and respectful in your testimony, and also try to be non-repetitive if you can, based on things that have already been said. So I'll start. First one I have signed in is Lydia Strong. Ms. Strong, do you want to testify? Please come forward and state your name for the record, and if I could also ask folks to keep their testimony to 3 minutes, please.
My name is Lydia Strong. Mr. Chairman, Mr. Vice Chairman, members of the committee, thank you for having me here. Give the opportunity. My name is Lydia Strong. I'm a licensed attorney in Brazil with over 25 years of legal experience. But more importantly, I'm a recent naturalized American citizen who is grateful for my constitutional rights to petition this committee today. Thank you for this opportunity. I'm here to address an important constitutional principle. The U.S. protects freedom of religion, absolutely, and belief, but conditional in practice. It means freedom of religions, belief is absolute, but freedom of religion's practice, it's not. This distinction is not controversial. It is well established in constitutional law. The First Amendment guarantees every individual the right to hold religious beliefs of their choosing. However, the Supreme Court has ruled that religion's practice may be regulated or prohibited when they conflict with neutral laws
designated to protect public safety, individual rights, and equal protection under the law. Based on the First Amendment, Americans are free to believe anything or nothing at all. That freedom is total. Let me be clear about religion's belief and religion's conduct. This is not about banning religions or beliefs. It is about ensuring that no religion's practice supersedes the Constitution, criminal law, or civil rights protections. Example of religion's practice that are not protected: abuses that constitute cruel or unusual punishment, forced marriages, violence justified by religion's doctrine, punishment against individuals for living a religion, illegal healing practices that endanger public health, child abuse or harmful rituals imposed on minors, animal abuse. These are all illegal, not because they are religions, but because they violate laws that apply to everyone equally. The Constitution does not permit parallel legal system that override state or federal law. There is one law in this country, and it applies to everyone. The courts have repeatedly affirmed that the government may not target religion, but it also may not accept harmful conduct solely because its religions motivate.
Ms. Strong, if you could please conclude.
Thank you. Thank you. This balance protects both religions, freedom, and rule of law.
Any
Yes,
more?
sir.
Ms. Strong, do you have any final comment?
Yes, sir. I gave a very paper for you, have more deeply one, because I tried to get my time for 3 minutes.
Sure. Well, thank you. We do have those written submissions as well. Senators, do you have any questions for Ms. Strong? Okay, I don't see any. Ms. Strong, thank you so much for
Thank
taking
you
time.
so much for the opportunity.
Appreciate you coming today. Okay. All right. Next on the list, I have Caleb Perk. Is Mr. Perk here? Mr. Perk, welcome to the committee. If you could state your name for the record, please, and then also keep your comments to 3 minutes, if you would.
Wonderful. Thank you, Chairman Lakey, members of the committee. My name is Caleb Pierce, and I have served as General Counsel for the Idaho Family Policy Center, on whose behalf I'm here today. I want to start by thanking Senator Foreman for trying to prevent the application of foreign law that is antithetical to America's heritage, but we are opposed to the language contained in this bill. Christianity forms the basis of the American legal tradition. The U.S. Supreme Court observed in 1892 that this is a Christian nation and has been since before its founding as an heir of the English common law. That legal tradition established the societal framework that has always allowed Americans to flourish. However, the language contained in this bill would directly undermine the very legal tradition that the bill tries to protect. By prohibiting any reference to decisions based on a body of religious or cultural law, this legislation could tie the hands of judges who wish to reason in accordance with our nation's history and tradition. For example, this legislation could prevent a judge from providing historical context on the institution of marriage by citing William Blackstone. Blackstone most influenced the founders' thinking on the common law and is still regularly cited by justices on the United States Supreme Court, ranging on the ideological spectrum from Justice Sotomayor to Justice Thomas. Blackstone cited scripture in discussing marriage as the common law always defined marriage, as between a man and a woman. But because the Supreme Court decreed that there is a constitutional right to marriage beyond that historical understanding, Senate Bill 1233 could be interpreted to prohibit a judge from even citing Blackstone's influential commentaries on that issue. Similarly, if Senate Bill 1233 had been in effect when Roe v. Wade declared a constitutional right to abortion, this bill could have been interpreted to prohibit a judge from even citing the Declaration of Independence's assertion that all men are created equal and endowed by their Creator with certain unalienable rights, if done so to reason that the preborn are entitled to protection, because that language is clearly based on a body of religious law. Unfortunately, Senate Bill 1233 would only further enshrine secularism in our law, undermining rather than furthering our Christian heritage. We ask that you hold the bill in committee. Thank you. I'm happy to answer any questions that the committee has.
Thank you, Mr. Pierce. Apologize for pronouncing that incorrectly previously, but thank you. Any questions for Mr. Pierce? Senator Ruckte.
Thank you, Mr. Chairman. Mr. Pierce, so it's my understanding that your concerns with the bill is, from your perspective, the intent is that it ensures Idaho courts and their decisions do not promote any religion over any other, including what you would say is the Christian tradition of the United States.
Mr. Pierce.
Chairman Lakey, Senator Ruckte, our concern with the bill is the breadth of the language. Because the language prohibits any decree or citation to any sort of decision that's based in or even derived from any body of religious or cultural law, it's our belief that this could be interpreted to prohibit some of even the founding sources that were used by the founders in citation to those.
Okay.
Any other questions for Mr. Pierce? Okay, I don't see any. Mr. Pierce, thank you for coming today.
Thank you.
Okay, come on. All right, next I have, I'm hoping I'm pronouncing this right, O'Neill Isho. Mr. Isho, welcome to our committee. If you could also state your name for the record, please, and then please try to keep your comments to 3 minutes.
Thank you so much, Chairman, and dear members of the committee. My name is Onel Isha, resident of District 21. I'm here to represent myself, and I'm here to testify in favor of the Senate Bill 1233. That is because I was born and raised in a country in Iraq where the laws of that country, there are religious, tribal, cultural laws that supersedes the constitution of that country. These laws makes it that if you go to work and for whatever reasons you are found to be guilty of whatever violation of these cultural laws is, that could possibly mean you can come back home minus a limp, or that is perhaps if you don't come back in a coffin. And that I lived in a country where any person doesn't have any freedom of having what our brothers and sisters in the Democratic Party would call the LGBTQ or pride rights, because these laws actually prohibit the practice of such lifestyles, and it will be sentenced the people who ever practice these things to absolute death. So I would love to see that the laws of the Constitution to be upheld. However, I just would like to acknowledge in respect to the previous respectful gentleman who testified before me, I wouldn't personally mind for this bill to be sent to the amending order to address all the concerns of the language of the bill. However, the intents of the bill are pure, and I would be happy to see this bill being passed. Thank you so much, and I'll be standing here for any further questions.
Thank you, Mr. Isho. Any questions? I don't see any. Thank you for coming today. I appreciate it. Okay. Next, I'll go with Samuel Lair. Mr. Lair, you also know the drill. Please come forward, state your name for the record, and then try to keep your comments to 3 minutes, please.
Thank you, Chairman, members of the committee. My name is Samuel Lair. I am the Legislative Director for the Idaho Freedom Foundation, and I am also a PhD candidate at Hillsdale College. My specialty is the political, legal, and philosophic theory of the American founding. Unfortunately, I'm here in opposition of this legislation, although I appreciate its intent. And I'd like to echo some of the concerns mentioned by my friends at IFBC, although on a slightly similar, different note, which is on the cultural piece. As the good senator mentioned, this legislation does not single out a single body of religious or cultural law, and I'm afraid that in pursuing that goal, the net might have been cast overbroad. Obviously, our legal tradition is varied, going back to the American founding, and it includes the English common law tradition, right, that goes back all the way into the early 12th century. Within that space, it is not fully, if you look at if you look back fully to the language of the legislation, it states that any body of religious or cultural law that does not fully support and conform with the rights of citizens as defined in the United States Constitution and the Constitution of the state of Idaho are prohibited. Under the surplusage canon, every single piece of wording in this statute has to be considered meaningful, meaning that if something does not fully support and conform those rights as enumerated in the Constitution, that it cannot be cited. This poses a difficulty for our English common law tradition, which did not develop organically in the United States. It developed under a monarchic system, as illustrated by the fact that Thomas Jefferson in the Notes on the State of Virginia talks about how our political principles are a composition of the freest principles of the English Constitution, with others derived from natural right and reason. He says the freest principles because part of our English common law tradition obviously does not conform with a natural rights republic. Mr. Pierce here mentioned Blackstone. I'd also like to mention that Sir Edward Coke is widely regarded as one of the greatest legal theorists in the history of the West and cited by the Supreme Court over 70 times. And under the strict interpretation of the plain meaning of this statutory language, he would also be prohibited from being cited in any decisions coming before a court here in Idaho. So on that basis, I believe that the legislation might be overbroad in its application, and while it has I appreciate its intent, I believe that a better step forward would be sending this to the amending order to address some of these concerns that myself and some other members here have addressed. Thank you.
Thank you, Mr. Lair. Any questions for Mr. Lair? Okay, I don't see any. Thank you for coming today.
Thank you.
Okay. For those that have offered comments from a written document or a written testimony, Sharon would appreciate it if you would leave a copy or email her a copy, just so it helps her with the minutes for our meeting, if you're so inclined. Okay, next I have Victor Badra. Mr. Badra, welcome to our committee. Please come forward. If you would also state your name for the record, and if you could keep your comments to 3 minutes as well.
Thank you. My name is Victor Badra, born in Jordan, grew up in Jordan. In 1970, I immigrated to America at 26 years old. In 1976, I became a proud American citizen, enjoying my life. I immigrated legally, just to mention that. I'm enjoying my life and living the American dream. As a Christian born in Jordan and growing in Jordan, I was considered by Sharia law a second-class citizen. My great-grandfather, which my father knows him, but, you know, I'm old now, and imagine before. My great-grandfather was paying every month jizya, and if you know what jizya is, like extra taxation for Christians, to save their lives, to stay Christian. Otherwise, they have other two choices, is to become Muslim, convert to Islam, or death, one of the two. Today, I'm standing here to testify to say that Sharia law is completely incomparable with our great American laws. In American law, all people are equal. In Sharia law, anyone or any group not Muslim, they considered are second-class citizens. No age limit for the marriage, for the girl to get married. A marriage contract could take place at any time after birth, and the marriage will be consummated at age 9 years old. In Sharia law, non-Muslim cannot rule. So if I am in Jordan now, I can't be a ruler of anything, even for a group not Muslim too. Women are forbidden from becoming presidents or judge. In Sharia law, husband has the right to beat his wife, and he is not obligated to explain that to anyone or even to the police. He is protected by Sharia law to beat his wife. Under Sharia law, man can marry up to 4 wives, and none of the wives has the right to divorce. Plus, there are many things to have more children and other things. Under Sharia law, the punishment for a couple having premarital sex, 100 to 140 lashes in public.
Mr. Badra, the 3 minutes is up. If you could summarize and conclude, please.
Oh. Well, parents have, I don't know, there are a couple of things if I say it parents have the legal rights to perform female genital mutilation on daughters. In Sharia law, no community property between husband and wife, and the husband's property does not go to the wife after death. That's why Muslim people here, especially men, they want Sharia law because they don't want to pay 1 cent to the wife. And back home or in countries they use Sharia law, when the man say you are divorced, she's out. She with her clothes. That's it. She go back to her father or to her brother or whatever. And there are a couple, but I don't want to take your time. But
Thank you, Mr.
Thank
Badra.
you.
Let me see if we have any questions. Any questions, senators? Okay, I don't see any. Mr. Badra, thank you for taking time to be with us
thank
today.
you.
Okay, I have Rebecca Loomis, who is virtual. We'll try that.
Hello.
Ms. Loomis, can you hear us?
Yes.
Wonderful. If Ms. Loomis, if you could state your name for the record, please, and then there'll be a 3-minute timer you can see on your screen. Please try to stay to the 3 minutes.
I will do so. My name is Rebecca Loomis from Kendrick, Idaho, and thank you, Chairman, for having this opportunity. One of the very simple things, in my opinion, is that permitting any religious or cultural laws is in direct conflict with our U.S. Constitution. All that does is lead to chaos and confusion among both in the court system and also American citizens who are confused by all the requirements of Sharia law. I am in strong support of Senator Foreman's bill, and I think it should move forward as we have it written right now. Thank you.
Thank you, Ms. Loomis. Any questions for Ms. Loomis? Okay, I don't see any. Ms. Loomis, thank you for taking time to be with us today.
Thank you very much.
Okay, as I mentioned, I have quite a number of people signed in favor, but I'm through those that were noted as wanting to testify. Are there others that would like to offer testimony? Craig, please come on up. That's okay. You're here and
Before you start that clock, may I make a suggestion? We ought to have a forum for senators and people like Victor Badra, who may take a little time getting some very important messages out about the culture that is now occupying 2% of our Idaho, 40,000. And Mark Twain once
Craig,
said,
if you could state your name for the record, please.
Craig Schoberg.
Thank you, Mr. Schober. So go ahead. I'll start the clock and you can
Okay,
proceed.
I've studied Islam for about 15 years under some deep, experienced mentors. Sharia law represents the most anti-freedom, anti-American culture that is devoutly organized to deviate, hate, abuse, subrogate, destroy our way of life. It's been going on since the 7th century and got big in the 1920s, and then again 1990s, and again in 2008. We now have an unbelievable fraud here and death of the Iranian protesting oppressive subhuman totalitarians in Iran right now. We've all heard of jihad. That's the war against infidels. A quiet jihad is a hijra, migration to other countries. Notice how distressed refugees from oil-rich companies come across the globe in large numbers, mostly military-aged men. They come to Western countries. European countries are 5 to 10 years beyond us in their hijra invasion. You want to have no-go zones here? Well, they're here and they're growing. Sharia law and the Hadith, Reliance upon the Traveler, have told Muslims how to expand. This is their taqiyya. Taqiyya, you must lie. You forward yourself. Concealing the true truth in nature, seeking to be here. Sort of adds up when we catch how much Somali fraud has been going on, where Al-Shabaab is the benefit of fraudulent dealings up to the billions. Constitutionally, Sharia law offers no free speech, Look at all that died in Iran the last few weeks. Convert to Islam or die. Where's the compromise? People say we have to have a compromise. There is none. If one leaves Islam or speaks disdain, they are labeled apostate and killed. No 73 virgins and a life of luxury in the hereafter for you unless you do bad things. There is no equality in Sharia law. Women cannot own, inherit. Women cannot vote. Women are beaten and raped by husbands and young girls and married off and sex at 9. Wherever Sharia law has furthered crimes and they pretend to is honorable and normal. They're planning to have about 5,000 attorneys growing in the Muslim Brotherhood here in America to help fight the battles that you guys discuss, legal ramifications. Okay, Sharia law got included in the 2010 Obamacare law. My copy of that law says that Muslims are specifically exempted from having to pay into it, yet they still get the health care benefits. How did that happen? That was a Sharia law plant from 15, 20 years ago. Sharia law officially taken over segments to New York City Police Department. They have a Muslim police department. If the usual cop on the beat is told by a gentleman, I'm a Muslim, you have to stand down and call in the Muslim police and their green cops, separate division of the police force. Now for Sharia. Sharia law is also happening here. My landlord, property manager, tells me Boise Police Department would not respond to a man with a gun, a known tenant, him and his one-legged brother, threatening vendors coming to the property. Police would not report. They would not come. Muslim Brotherhood Care Office in Boise, been here for 8 years. There are more Muslim student associations on campuses than there are combined Democratic and Republican student unions. Anybody here, whatever happened?
Summarize and conclude.
Yep. And you guys have the power to do something. As Dan said, there's all these other states that have already done this, and may we stand on our Constitution to reign supreme for our country. Thank you very much.
Thank you, Mr. Schober. Any questions for Mr. Schober? I don't see any. Mr. Schober, thank you. Appreciate you coming today. Are there others that would like to offer any testimony today? Okay, I don't see any. As I said, I had a number. Oh, did somebody raise your hand? Anybody want to testify? Yes, sir. No hurry. There's no time limit to get to the podium.
Okay, thank you. All right.
And sir, if you could, you saw how it went, please state your name for the record, and then try to keep your testimony to 3 minutes as well, please.
My name is William Thomas Howie, and I'm here to testify in favor of S 1233. And I thank Senator Foreman for his presentation, because everything I have to say would be in that presentation. So as you suggested not to repeat, I'll just make this short, thanking him for saying what I wanted to say. So I'm simply here to be in favor of S 1233, the way it stands, to move forward.
Thank you, Mr. Howie. Any questions, senators? All right, I don't see any. Ms. Chari, thank you for coming today. Okay, Senator, I don't have anyone else that wanted to offer any testimony. All right, Senator Foreman, we'll let you conclude.
Thank you, Mr. Chairman. When we're talking legislation in this environment, words matter. Now, I heard it stated by folks acting in good faith, and I do appreciate everybody's inputs and comments, and good on them for showing up today to testify, either pro or con. But it was stated that this bill would prohibit judgments based on any body of religious law. That is factually incorrect. Please read the bill. My bill says it would prohibit judgments based on a body of religious or cultural law that does not fully support and conform to the rights of citizens as defined in the U.S. and state constitutions. Now, for the last 250 years, judges have decided what is constitutional and what isn't. And it's been working just fine, even though our laws originally, in some degree, continually have been based on Judeo-Christian moral and ethical principles. Those who are opposed to this legislation because they fear some courts may use it to rule in ways contrary to what the Constitution traditionally dictates based on activism or political motivations should not, in essence, have such concerns with this proposed legislation. They should instead have serious concern over the judges who might engage in political activism from the bench and thereby render judgments not in keeping with constitutional tradition. Their concerns are misplaced, as the problem is not with this legislation. Now, we must never allow ourselves to become so fearful of the myriads of possible what-ifs resultant of our actions that we refrain from speaking, endorsing, and supporting statements of simple understanding and patriotic truth, like those found in this simple but profound legislation. It is important to maintain a clear focus on the simple but important meaning and purpose of this legislation, the sole purpose of which is to prevent the use in our state courts of any body of religious or cultural law that does not fully support and conform with the rights of all citizens as defined in the United States Constitution and the Constitution of the state of Idaho. Now, I have full faith in our judges who make rulings every day that they are wise enough, schooled enough, and learned enough to decide what is constitutional and what isn't. They do it day in and day out, and they do a fine job of it. The text of this bill serves to act as a reaffirmation of our appreciation of and support for our existing body of law that is endemic to supporting the American way of life and our collective values we have enjoyed as a nation for the last 250 years. The system works, and we should never be afraid to support such legislation that I propose out of anticipation of any attempt to twist its meaning and intent. Thank you, Mr. Chairman.
Thank you, Senator Foreman. Any other questions, Senators? I don't see any. Senator Foreman, thank you. We'll invite you to come back up. And Senators, we have Senate Bill 1233 before us. I'd open the committee for a motion or discussion. Senator Lenny.
Thank you, Mr. Chair, for discussion. So a bill very similar to this was tried by Oklahoma in 2010. It immediately went to court and died in the 10th Circuit Court of Appeals because there was a fundamental problem with that bill, First Amendment problem with that bill in Oklahoma with how it was written, and that was because it targeted religious or cultural law instead of something like foreign law. It targeted religious law specifically. There was the Oklahoma courts, it made it to the 10th Circuit is what I'm trying to say. And so I think this bill has the same problem that Oklahoma ran into. It will likely be seen as, I would assume, violating the Establishment Clause in the First Amendment because it has some of the same text. Anytime you target religious law, I think it's going to be a problem in the courts. The fix, I think, is a simple one. It's to target foreign law, not religious law. And that neutral type language would avoid any kind of First Amendment problem, but this bill as written uses the same type of language Oklahoma did. And if you think the 10th Circuit had a field day with the Oklahoma bill, if this passed, it would go to the 9th Circuit Court of Appeals, and there's no, it would be, have no chance of getting out of the 9th Circuit Court of Appeals, in my humble opinion. I think a federal judge would strike this down, and I'd rather pass something that is clean, because I do agree with the intention. I don't think anyone on this committee or in this room would likely want to implement Sharia law, but I would also rather not walk into a loss with our eyes wide open when this hits the Ninth Circuit Court of Appeals. So there's a right way to do this. We can fix it, we can do something else, but I don't think this, as written, will survive court. Thank you, Mr. Chairman.
Senator Lenny, Senator Kaiser.
Thank you, Mr. Chair. I'd just like to echo some of the similar concerns. A lot of mention of Sharia law here today. I don't believe anybody in the committee is advocating for that system reform of government, but words do matter, and I think this process is slow, albeit maybe frustrating, because it allows an opportunity for us to perfect the legislation as more eyes review this. And I do believe that it would, in fact, prohibit judges from appealing to or ruling in favor of principles of common law or natural law. The legislation itself states that no jurisdiction should consider or apply any judgment. I think that the history and tradition test has often been used by the Supreme Court, particularly by Justice Alito in cases such as Dobbs versus Jackson, which overturned Roe v. Wade. So I think that this could use some work. I don't know if the sponsor is open for any additional edits, but I do believe it's important that we consider all of those things in this decision. So I'll be opposing this today, as written.
Thank you, Senator Kaiser. Senator Foreman.
Thank you, Mr. Chairman. I'd just like to respond to the comments of my colleagues here because they're in error. All due respect. The attorney bill that was, or the Oklahoma bill that was referenced, the reason it was shot down, based on my discussions with the staff at the Idaho Attorney General's office, is because it specifically mentioned a target religion, which was Sharia law, Islam. That's why the Oklahoma Supreme Court shot it down. And that's why this bill does not have any reference to a specific religion. That advice came straight from the Idaho Attorney General's office, who says they have no constitutional problem whatsoever with this bill. I wasn't satisfied with just that, so I ran it past the Idaho State Supreme Court. Same answer. As long as there's no specificity as to what religion we're referring to, if it's stated in general, the Supreme Court justices, and I don't know which ones looked at it, it was relayed to me they had no problem with the bill constitutionally as written. So much for Oklahoma. Reference to foreign law. We have English law and French law dating way back to the formation of our country that are interwoven along with Judeo-Christian principles, morals, and ethics into our existing body of law. So to say we're going to shift our concern and hedge against a possible overturn in the courts of this legislation by shifting away from the word religious and cultural and replacing it with foreign, oh boy, does that open a can of worms then, using the same logic, which, quite frankly, again, all due respect, I think is faulty. We have an existing court system. It's been in business for a long time. These issues have been dealt with over and over and over again. Again, read the bill. The bill says we want to, I'm speaking.
Senator Lenny.
I object to some of the tone Senator Foreman's taking here, disparaging intention and things like that. I think we should just keep it to the bill instead of disparaging his colleagues on the committee.
I'm not aware of having disparaged anybody. I'm defending my legislation and telling you the process I went through. Your statements, Senator, were factually incorrect. I have a right to point that out, which is all I'm doing.
Let me make a ruling. The chair finds let's just factual corrections are appropriate. Let's just try to avoid any insinuation of motive or other things on the part of others. But I think it's okay to say you disagree with a statement of someone else. So let's always keep it courteous and professional, and go ahead, Senator.
Well, thank you, Mr. Chairman. And I will point out, I said, Senators, with all due respect, I said your assertions are incorrect, and they are incorrect. I see nothing hostile about that. So again, we need to focus on what the bill says, not what it doesn't say, not what it could say, not what people who could impart some ulterior meaning to the bill and try to overturn it in a court of law. If we're afraid to go forward with what we stand for and what a statement as to what we stand for and believe in is something as simple as this, as clear cut, a patriotic statement that we want to keep our court system the way it is and not have it infiltrated by anybody's body of law that doesn't support constitutional rights. I can't see how anyone would disagree with that. And if the Ninth Circuit or somebody else eventually challenges this, then so be it. But if we're afraid to take the first step, then we're dead in the water. And quite frankly, I'm not afraid to take the first step. Thank you, Mr. Chairman.
Thank you, Senator Farmer. I would add, I don't think any of us are afraid of any particular position on this committee. I know you all well. All right. Any other comments? I'll maybe chime in since we kind of seem to be going down this direction. I do support the legislation. Appreciate the clarification on not calling out any particular religion. I've taken an oath multiple times to uphold the Constitution, and that's the ultimate backstop on this legislation. If something does conform with the Constitution, then it can be used. If it doesn't, then it can't. And I agree with the statement that we have case law interpreting our Constitution, both at the state and national level, that provides the sideboards as to what in our legal history is constitutional. So I'm comfortable with the backstop being our Constitution. So I will be supporting the bill. Other comments? Senator
Mr. Chairman,
Rucky?
I don't think we have a motion at this point.
That's correct. I haven't heard a motion yet, so I am allowing a fair bit of discussion without a motion, but that's the chair's prerogative. So with that, is there a motion regarding Senate Bill 1233? Senator Ricks.
Yeah, I move that we send Senate Bill 1233 to the floor with a due pass recommendation.
Have a motion to send Senate Bill 1233 to the floor with a due pass. Is there a second? A second from Senator Foreman. Any further discussion? Senator Rucky. And we do have health and welfare coming. Let's try to have a hard stop at 5 till.
Okay. Thank you, Mr. Chairman. As my comments probably indicated, I've struggled with the bill, but ultimately, when I read the language of the bill, and I do think that's what Senator Foreman indicated was we need to stick with the language of the bill. It is, I think it's perhaps, well, I consider it be ambiguous to some extent, but I can tell you that I'm going to support the bill, but I do so because when I read the bill and when I hear the testimony, what I understand the bill to be is a religious neutral bill. In other words, it refers back to adhering to the United States Constitution and the Constitution of the State of Idaho. And in both of those documents, the First Amendment, in particular in the United States Constitution, the First Amendment of the Bill of Rights, and in the Constitution of the State of Idaho, there are a couple of things that are made very clear, and that those two things are these, that there is to be no state-sponsored religion, and that people's ability to practice their religion shouldn't be interfered with by the government. And so that's the wall between church and state. And based on that, I think the way the statute should be read is that it simply ensures that courts do not place in their decisions, rulings, decrees, judgments, and that they don't consider or enforce one religion over another or religion at all, which seems to me to be consistent with the United States Constitution, the Idaho Constitution, as the statute requires. So I'll be voting yes.
Thank you, Senator Rucky. Senator Shippey, we can keep it brief. I forgot about Senator Wintrow's RS. She says she can do it in 60 seconds, so we'll let her try that after we get done.
Thank you, Mr. Chairman. So I have similar concerns as what have been voiced here. I do appreciate the bill sponsor and what he's trying to accomplish, and I appreciate many of the testimonies that have been given here today.
Unfortunately, I don't think I could support this motion as the bill is currently written. I just have continuing concerns, but I would offer a substitute motion. I move to send Senate Bill 1233 to the 14th order.
We have a motion from Senator Shippey and a second from Senator Kaiser to send Senate Bill 1233 to the amending order. Any discussion on that motion? Senator Foreman.
Thank you, Mr. Chairman. I would take that as a hostile move to rewrite the bill, and I won't support it.
Thank you, Senator. That does carry some weight with me.
Mr. Chair.
Senator Lenny.
Sorry. Could we do a roll call vote on this, please?
Sure.
Thank you.
Any other discussion on the substitute motion? All right, so all in favor of sending Senate Bill 1233 to the amending order for possible amendment, that's the motion. I'll have Sharon take a roll call vote. This is sending it to the 14th, yes.
No.
Not yet.
Nay.
Nay.
Aye.
Nay. All right, so motion fails. That brings us back to the original motion to send 1233 to the floor with a due pass. Let's go ahead and take a roll call on this one as well.
Aye.
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 Nay.
Aye. All right, motion carries. Senate Bill 1233 will be sent to the floor with a due pass.